Hello, my name's Justin Govier and I'm the Employment Law Partner here at IBB Solicitors. One of the problems many HR practitioners have faced over the years is how you go about having that difficult conversation with an employee who isn't performing as well as you'd like or whose attitude is not as you would like it to be, and you want to have a conversation around the problem that ultimately could lead to a compromise agreement or settlement agreement as they're now called. There are rules about what conversations are without prejudice, however they are incredibly grey and even us lawyers find it very difficult to be absolutely sure whether any given conversation will be covered by that principle. Recognising this problem, last summer the government set about a new initiative around settlement agreements, which used to be referred to as compromise agreements, and discussions leading to settlement agreements. The basic premise is that any discussion designed to lead to the termination of the employment with a compensatory package, usually an accompanying settlement agreement, will be protected from disclosure in the front of any subsequent employment tribunals. Obviously, these sorts of discussions can be very damaging if the employee turns up at the employment tribunal and refers to them. It basically shows that the employer had it in for them all along, or at least that's what the employee will say, and it's likely that a judge may come to that conclusion. The new initiative was generally well welcomed and well accepted by the HR community. However, there are, as always with new legislation, fundamental issues which we now need to overcome. The protection from immunity within the employment tribunals is lost if the employee alleges discrimination. So if, for example, the employee says, "You're doing this because I'm over 60, then that conversation can be referred to in a subsequent tribunal. Furthermore, if an employer acts improperly in the way they go about the discussions or the contents of the discussions, then again the protection will be lost. Obvious examples are if you bully or harass an employee within those discussions. But as always, it's a fine line and there will be lots of grey areas which will lead to a number of test cases. Acas have produced a helpful guidance on settlement discussions. However, it runs to 85 pages. It does have some useful precedent template letters and it has some do's and don'ts. However, the reality is that we need a body of test cases which will allow us to really see how the judges in the employment tribunal are going to deal with this issue and what they will accept and what they won't accept. Unfortunately, that means that some employers are going to find themselves on the wrong end of the test case, but it is a necessary evil. Ultimately, whether or not these discussions are successful will depend on the level of compensation that is being offered. If that can be agreed, a settlement agreement will be signed and this matter will never end up anywhere near an employment tribunal. If you would like to have a discussion about what the appropriate level of compensation may be for any given scenario, or some practical advice about how you should go about these discussions, the letters that should go with them, the notes and minutes that should be kept, then please do not hesitate to give me a call here at IBB.